good afternoon, everyone. We're going to have to wait before we can actually start giving support or not on issues, but because we need one more person up here. But we're going to do some introductory information. Melanie, would you like to lead us through that, please?
I'm actually going to ask Amanda to
Or Amanda,
talk
please.
about
That was introduction from Amanda. Yeah, there you go.
Yes, for an Amanda.
Yeah.
And then I'm going to take up where she leaves off on the local bill section, just to talk about how these local bills run through the process in and here locally.
Please, go ahead, Amanda.
Sure. So
Thank you.
today's state legislation discussion is going to focus on the local and bi-county bills that have been introduced or that have been filed at the delegation. I did just want to briefly remind you that that you are limiting the number of bills that you are taking up. There are a number of bills before you, but that's because what you agreed to do was to talk about the local and bi-county bills, because it of course affects the county greatly. So with that, Melanie can kind of walk through the process.
Okay. So
And we now have our fifth member, so we can actually begin, too. Okay. Go ahead, please.
well, I am going to just mention the process really quickly, just for the edification of people who were relatively new last year and might not have caught some of the subtleties. But this is the local bill package, and almost all of these bills, with the exception, I think, of two, have been introduced by members of the Senate, or the Senate and House delegations, our state delegation. Several of them listed here are bills that came up out of the county. They were requested on behalf of the county government, and you've all been made aware of them, you've agreed to them, so there's really not much to be said about that. So tonight is the first of the two House delegation public bill hearings on this set of local and bi-county bills. So they'll hear it, and they will then, of sorts, assign them to one of the House committees for work sessions that will begin in Annapolis once the session convenes, which is the second Wednesday in January. The House delegation takes these bills up first. If they're bi-county bills, there also has to be agreement from Prince George's County on pieces of legislation. If the House delegation supports the bills, then they go across the street to the Senate delegation for them to actually hold a public hearing on, because the public hearing tonight is actually the House delegation, although lots of times we have Senate members join them. Senate delegation dispenses the bill, agrees to it, or doesn't agree to it. They only take up those bills that were passed by the House delegation. And if they do, they're then taken up by a standing committee in the House. And that standing committee typically will not take up a county bill unless they receive a letter from the delegation supporting the legislation. And then the process goes just as if it was a normal bill from there, as if it was a statewide bill. Going up the House floor, across the Senate, et cetera.
Okay.
So that's kind of the quick process. And so you have a number of bills before you, but they're organized in a way so that the public hearings that are held tonight on this set of bills are the first sections of this memo. We'll discuss the bills. Amazingly, I don't have any of them assigned.
Well, let me just say that we have 25 different bills to go through, and we have to be out of here by 2.
Right.
So we will be working quickly.
We're going to work quick.
Thank you.
Kathleen and Amy have the bulk of the bills. We'll start there, and we'll then Amanda will talk about what the council staff recommendation is to you all.
Good afternoon. The first bill for discussion is about deer management permits in the agricultural reserve. This bill would allow someone to obtain a deer management permit from the State Department of Natural Resources to use a rifle to harvest deer in the agricultural reserve year-round. Currently, rifles are prohibited to hunt deer in Montgomery County at any time. There is areas in Frederick County that allow deer management permit holders to hunt with rifles year-round. It's a fairly stringent process to obtain one of the permits. They have to come out and investigate, look at the crop damage, and then the investigator from the state makes a recommendation as to whether a permit is necessary and how many deer should be harvested. Upon talking to the Office of Agriculture here, I would note that even when the deer management permits are given to the licensees, to the farmers, or to an agent, they typically do not harvest as many deer as allowed under the permit. It's just, not feasible to do so. The county executive supports the bill.
Any question?
So I will just tell you that council staff does recommend support of it, and I just wanted to alert you that we have, while I am sitting here right now, and I'll tell you what the staff recommendation is, all of the central staff analysts have contributed to the comments in here, so if you have any specific questions, it could be that another analyst needs to come up and chat with you about it.
Okay. Any question, or are we going on that? Go ahead. Go ahead. Well, what's the question?
Do we need motions? I presume we do, motions and seconds for the bills.
Is that the way we should be doing it? Motions or seconds, or just consensus?
Or you can do it without objection, of course.
Yeah, okay.
That's
All
your
right.
call.
Okay.
Most of the time, it's done without objection, unless, of course, there is objection.
Is there objection?
And then which case you would need motions and seconds.
Right.
Okay.
Is there an objection? Without objection. Thank you very much. Next.
Okay, so this next bill relates to a bill, thank you, Amy. This bill relates to a bill that may sound familiar from last year. This is a bill that requires that revenues collected from Montgomery County's local agricultural transfer tax be dedicated to agricultural or ag preservation purposes. Right now, those funds flow into our general fund. So, as you see in the memo, the annual revenues for that tax have averaged about $500,000 during the last 5 years. So we do, the second thing that the bill does is it amends the offset provisions of current law. So under current law, there are offsets, actually 100% offset during a transfer that is made within 5 years of a change to a non-agricultural use. If the land is transferred longer than 5 years before there's a change to agricultural use, there's no offset. So we're recommending an amendment to the bill that would retain the part of current law that allows the county to collect 100% of the county tax within the 5-year look-back period, but accept the part of the bill that reduces from 100% to 65% the offset for the longer than 5-year period. So essentially, the bill would allow collection of 35% of the tax for a longer than 5-year look-back and retain county law for transfers within the 5-year look-back.
So the staff recommendation is to support it with amendments to remove the offset language. Is there an objection? Question? Well, why don't you use your, go ahead.
Gene, the county programs $200 million from this every year? That's what the memo says? That seems somehow high.
It's 500,000, and half of that goes into the CIP. I don't remember seeing 200 million.
Where'd you see that?
Maybe that was
Am I reading the right thing?
oh yeah, you're reading, I'm
Sorry,
sorry.
it says-
Sorry, that was a typo.
Okay,
200,000.
100,000.
So half of it is already
Stakes are
programmed.
much different.
Yeah,
1,000 here, 1,000 there.
yeah,
It's a couple $100 billion among colleagues.
yeah.
So I point out for the record, I did read the chart.
First time for everything.
Right.
On the first page?
Staff's intent was to just to note that we currently are already programming half of it for the purposes. So the 500,000 that's noted by the executive report, I suggested none of it's being programmed. I didn't want council members to realize that that was the case.
Okay, any objection? So, without objection. Next, please, 1520.
You can also name the bill again, too.
That was a good catch.
MC 15-20 relates to alcoholic beverages in the town of Kensington. This bill was requested on behalf of the town. Just a little bit of background, Kensington and several other areas like Damascus and Laytonsville have somewhat different alcohol laws that are a little more restrictive in some ways. And what this is doing is updating outdated language relating to the town. It's doing several other things, including letting the Board of License Commissioners issue up to 3 beer and wine tasting licenses. It will allow for the Class 9 smaller distillery to sell what it distills for on and off premise consumption. And then it will also open it up for the Class A beer wine off premise licenses. There's currently only 4 can be in aggregate, with the other off-premise licenses can be allowed. This would allow for a public hearing to issue more, and then the request is made to the Board of License Commissioners so that they can issue the license. I do want to note that the sponsor of the bill has this bill listed as a placeholder bill. We do expect to see some amendments, just, I think, tightening the bill up and clarifying some language. The county executive supports the bill.
Council staff recommends support. Any objection? Without objection. And I did want to take a moment to welcome, we have some state delegates in the audience with us, Delegate Al Carr, Delegate Julie Polakovich Carr, and Delegate David Moon. Welcome. Next is 1620.
Okay, this may also sound a bit familiar in terms of subject matter from last year. MC 1620 deals with country clubs and golf courses, and it would impose an annual land preservation fee of $100,000 on certain types of golf courses and country clubs. In particular, if the club is eligible for a special assessment under state law, which assesses their property at $1,000 per acre in exchange for an agreement with the state, essentially to maintain the operations of the club and keep open space. And the second criteria is if the club is located on land that has an average market value of at least $500,000 per acre. I'll share with you that, and I know the sponsors in the audience, and what he has shared with us is that this is a work in progress, and I think I think staff would recommend, based on the sponsors' advice to us, that it's still a work in progress and it's likely to change. You might want to hold off on a position, but I will say that the county attorney's office believes that the fee that's created by this bill is actually a tax. It's a property tax because it's based solely on the characteristic of owning property, and it violates the Constitution because all classes of property, i.e. golf courses and clubs throughout the state in a certain class, have to be treated the same. So we've shared that with Delegate Moon. I think he understands and is I don't think he's contesting that. He understands. I think he appreciates that we shared the county attorney's advice with him, and my understanding is he's working on an alternative.
Thank you. Councilmember Rice, please.
Well, thank you very much, Mr. Vice President, and I just wanted to agree with council staff, thank you, that I'd recommend no position on this. I know that we've seen a bill similar to it before, and I knew that there was some debate amongst council members beforehand. I think no position is the right stance for us to take at this point.
Thank you very much. Councilmember Jawando, please. The way these lights are set up, you can't tell who's who up here.
Thank you, Mr. Vice President, for one more day. Well, you know.
Yeah, I still got to be nice to you guys. I really do. Yeah.
Exactly.
Don't give it up yet.
Yeah.
You know, I got a full day. It's going to be nice.
It ends tomorrow.
Yeah, it's tough. Tough league.
Andrew's going to squeeze out here.
Tough league.
We've talked about a similar bill. I just wanted to state that, you know, while I am sensitive to the constitutional concerns and the legal concerns of the county attorney, in principle, I agree with this, that this loophole should be closed, and that it should be assessed on market value, and we should, you know, so I just, to the sponsor, I don't see he's behind Amanda, but I just want to state that on the record. And I think, you know, there's the larger issue of property tax, everything being applied the same rate depending on what it is. I think is something I'm going to be looking at with some other colleagues in Annapolis. So I just want to foreshadow that. But But I hope we come, I think the right position would be no position for now, and then come back to it when we have the clarification from the bill sponsor. But certainly sympathetic, at least this council member is.
Right now, it's recommended that we take no position. Is that without objection? And it is. Thank you very much. Next is 2020.
This bill deals with residential property advertisements and sale regarding school district information. What it does is it would prohibit licensed real estate brokers, salespersons, and associates from including the name of the school district in an advertisement for sale or rent of any residential property located in Montgomery County. The state's real estate commission would be required to enforce the provision, and it would be authorized to receive complaints, conduct investigations, issue subpoenas, and hold hearings. Second thing that the bill does is it would require a notice to home buyers regarding Montgomery County school districts, and that would be included in all sales contracts just for single-family residential property in Montgomery County. The buyer would then be required to initial the notice acknowledging MCPS districts and boundaries are subject to change. I do want to note that the Office of the County Attorney advises that prohibiting the inclusion of school information in ads could potentially be viewed as unfairly restricting speech. This is commercial speech, but I did want to note that. The county executive supports with an amendment to strike the provision of the bill relating to the ads, so it would just leave the component where the person buying a single-family home would initial that they understand that the boundaries of schools in Montgomery County are subject to change at any time.
Mr. Friedson, Councilmember Friedson.
Yes, thank you. My understanding, similarly to the other bill with the same sponsor, is that the sponsor and stakeholders are still working out aspects of this bill, including some of the concerns related to advertising. And so I would recommend that we defer on this because we don't know what the ultimate bill is going to be pushing forward. I don't necessarily disagree with the county executive's position that there are concerns related to advertising, commercial speech, the similar constitutional questions, but I think we should defer so that we're actually voting on the bill that will be before the General Assembly and not what's currently introduced or will be introduced.
Any other thoughts on this matter? It's been suggested that we take no position. Is that without objection? And we will not take a position on that one. Next is 2420.
Okay, so this is Montgomery County Distracted Driving Monitoring Systems Authorization. This is a local enabling bill that would allow the county to place automated driving, distracted driving automated monitoring systems on highways located in Montgomery County. Similar to what we have for speed cameras and red light cameras and school bus cameras, it would be run through the Department of Police. The offenders would be mailed a civil citation not to exceed $500 or at a preset amount set by the chief judge of the district court with no points and could be contested in court. The police department and the county attorney have both reviewed the bill. The county executive has not yet reviewed this legislation. The police department actually had some pretty significant concerns, and Captain Didone is here if you would be willing to entertain.
Well, at this point, you're recommending that we do not take a position, is it?
Well, the county executive has not reviewed the bill yet, and there have been some serious concerns expressed by both the police and the county attorney with the technology, with the extent of expanding our automated enforcement systems already, with potential privacy issues with what is on a cell phone. There are some pretty significant wrinkles in the bill as we see it now, but again, the county executive has not reviewed the legislation.
Yeah, OIR hasn't recommended a position, but the council staff recommendation is no position.
No position. Is there any objection? Go ahead, please.
Thank you. Just to add a little color to the discussion here. So this is a proposed use of new technology that wasn't around a few years ago simply to enforce our existing laws. I was served in Annapolis on the committee when we passed the laws authorizing red light cameras and speed cameras and banned talking on your phone and also texting while driving. This doesn't expand or change what's legal or not legal. It's simply one more enforcement tool. I think we all know from the Vision Zero briefing that we are not doing a good job of expanding our of either meeting our Vision Zero targets or expanding our camera program for enforcement. And to me, that's not a reason not to seek the enabling authority to be able to expand our enforcement in the future in this way. This is a new Montgomery County company that's proposed this. These would be mounted cameras that could see driver behavior and issue a ticket that would still be screened by a human screener the same way your red light cameras are now. But we know we have an epidemic of distracted driving. There's 38,000 crashes each year in Maryland. NHTSA says it's $175 billion in costs nationally from distracted driving. And to me, while there are wrinkles to be worked out, there are wrinkles in all kinds of bills, especially having to do with new technology. That is not a good reason not for us not to seek the authority to use every tool in our toolbox to keep our residents safe, which is the commitment that we made when we took on Vision Zero. Thank you.
Councilmember Giundo, please.
Thank you, Mr. Chair. I think this is a bad idea. I will use this time as the only lawyer on the council. I don't use it often. I think there are serious privacy concerns here, as well as all the things that happen. The courts have ruled it's not private space, but we know a lot of private activity happens in the car. And what's on that phone, whether it be you're looking at your GPS, what else is going to be seen. I just think there's too many issues that come up with this, and the technology has not advanced far enough for us to go down this path. There's also the question of deployment, serious potential for racial equity issues and other types of, socioeconomic, where, as you have with all these issues, where are they going to be deployed? What's the cost of that? And which communities are they going to focus, and what information are they going to be capturing of activities in the car? So I would actually suggest that we be against this as opposed to no position. I'll settle for no position, but I just think this is a really dangerous path to go down.
Okay. Next is Councilmember Glass, please.
Thank you, Mr. Vice President. I appreciate Councilmember Hucker working with Senator Wallstreicher on trying to figure out how we tackle the nearly 600 pedestrian bicyclist incidents in Montgomery County, the 11 deaths that have occurred in the 2019 alone. But I have concerns about this legislation, the enabling legislation, and not being an attorney, but understanding the importance of civil liberties and personal privacy. I want to learn more from attorneys and from advocacy organizations how this would be applied and what the residual effects would be on simply commuting outside in your vehicle. So with that, I would recommend no position right now.
Councilmember Reamer, please.
Well, I was really happy to see this proposal. I mean, I think we don't have all the details figured out, but distracted driving is an epidemic. I have no doubt that the reason why pedestrian crashes are rising suddenly is just the explosion of distracted driving. And I understand that the technology, but this bill doesn't mandate any particular technology. We've been approached by a company, but it will be years before, sadly, the process works its way through. And there's a lot of time to work those kinds of questions out. So what else are we going to do about distracted driving? I mean, does anyone have any plan whatsoever to deal with distracted driving? I don't see a plan, in effect. I just, I certainly would welcome to hear about distracted driving and what we're doing about it, but I don't know that we, this may be an issue we want to take a little time with and not rush to a decision about as a body as well, but Captain Didon.
Thank you, Mr. Rimmer. Upon reviewing the recommendation, I recognize as the traffic safety advocate, I did have to come up with recommendations. You can't say no to one thing without coming to another. The three-part proposal that I'm recommending to Chief Jones that goes along with Councilmember Hucker's question during the Vision Zero conference is one that we do implement the pilot program using unmarked vehicles within the traffic division so that we can evaluate the effectiveness of being able to detect distracted driving on the roadway, and then evaluate that to see if it's a viable solution and then implement it to the full traffic squad as recommended in Vision Zero. Secondly, one of the things I want to do is April is the distracted driving month that is recognized by NHTSA and Maryland State Highway Safety Office. What I'm proposing to Chief Jones is that a few days a month we have what's called distracted driving blitz, where it's basically all hands on deck, officers that don't normally do traffic enforcement will be working out in the street, but is heavily publicized, marketed media. What we have to do is let people create that deterrent effect that the cops are out there, they're going to write tickets, it's zero tolerance, and today's the day. If we're doing this a couple days during the month, hopefully it'll be a carryover effect. We'll get officers that don't normally do the enforcement to do more enforcement. We do average 6,000 charges a year, but that's not changing behavior, so we have to do something more and different. And the final recommendation is for the senator is that my recommendation is that we implement a change in the law that takes this as a no-point violation and makes it a point violation. But not only 1 point, progressive points. So every time there's a violation that you get, your first violation is 1 point, your second violation is 2 points, your third violation is 3 points. And if you're going to continue to drive distracted and be dangerous on the highway and passing school buses, then at some point you're going to lose your license. We're going to get you off the road. And the one caveat that's going to be interesting and a tough wrinkle to get to Annapolis from my prior delegates is I want to mandate it no PVJ by the judges, because it does us no good to have a provisional where we have points assigned, but then they go to court and the judge just gives them probation before judgment. They don't get a point and it doesn't progress down there. So that's a proposal, three-part that I worked on. I'll gladly work with anybody on this. I agree completely with Councilmember Hucker and Reamer that this is out of control and we have to do more and do better.
Thank you very much. Did you finish? Yeah.
I'm finished.
Next is Councilmember Albornoz.
Thank you. I think clearly this has reached epidemic levels, and I think this is an all-hands-on-deck situation. I completely concur with that recommendation, Captain Didone, but I do believe that we're at a point now. I mean, there was my neighbor 2 houses over from me was involved in a horrific accident right on Connecticut Avenue, and I went to church with his daughters on Sunday. And I think clearly there is a lot that has to be worked out with this bill with regards to the legal aspects of it, the technology aspects of it, but the fact that it's an enabling bill and at least puts us in a position to even have those conversations to begin with and not wait yet another year for us to at least have those conversations is why I am supportive of this particular state bill.
Thank you. Councilmember Friedson.
Thank you. I'm totally appreciative of Councilmember Hucker and the comments that were just made by Councilmember Albornoz that distracted driving has reached a catastrophic scenario. The challenges that we face in the county seem almost insurmountable, and any tool that we have, we should be looking at, reviewing, being thoughtful and responsive. I appreciate the recommendation of other alternatives to this as well. I'm just concerned, I have a broader concern about state legislation and the way that we deal with this. I mean, our state partners will have the benefit of dozens and dozens of hours of review of all of the questions that we're talking about here. I do have some questions and concerns about privacy and about some of the issues that were raised and questions that were raised by Councilmember Glass and Councilmember Giwando. And I don't think we have the benefit of that here, and I think it's premature for us to use the power of the council's endorsement on a bill when we haven't been able to have the opportunity to have our questions answered, many of which have been raised already, I think all of which are legitimate. And so I would, even though I am totally sympathetic to the goal here, and I am supportive of anything that we can do to curb distracted driving and more broadly just to make our roads safer for everybody, especially pedestrians and bicyclists who are particularly vulnerable. I don't think that we're anywhere close to a point in time where we should be deciding on how we would vote on a bill that we don't even really vote on. And I also think, to the point of waiting till next session, we haven't even started this session yet. I mean, this is part of what confuses me about how we handle this process. This legislative session in Annapolis hasn't even started. The folks who are actually voting on these bills haven't even begun. It hasn't even been formally introduced from a session that's begun. And so I think that we're just not at the point yet where we ought to be taking a formal position. And so I think that the no position approach is a thoughtful one. I think we should be continuing the conversations for the other three recommendations, which I don't think necessarily are competing here. I think we ought to be looking into that independently, and I think we ought to move forward and see where this goes, and hopefully have a lot of our questions answered as we move forward.
Councilmember Hucker, please.
Thank you, Mr. President. Captain Didone, just to clarify, I'm glad to hear of your responsiveness on agreeing on the need for the unmarked cars, and the second point's escaping me. But on the third thing, your alternate proposal to pass state legislation that would allow points to be distributed and instruct judges to give no PBJ, neither of those could be, in my estimation, a local bill, right? They would have to be a statewide bill if they're going to be implemented by the MBA.
Correct.
Okay. Well, that's quite different than a local enabling bill allowing the latest technology to keep our residents safe. The chances of those bills passing in Annapolis, in my estimation, would be, they're probably decades away, if ever, having served on that committee. But anyway, I'm glad for the initiative, and I'm happy to testify for those bills. But I don't see them as a constructive alternative, given that I think the chances of them passing next to nil. I do believe we are in the business of making decisions. That's why we ran for these seats, and we draw the paycheck that comes with them. And we should be generally of the mind of seeking authority so we can work out the details. Saying there's no, we don't have all the details and every possible regulation in front of us before we can pass legislation is no standard I've ever seen a bill held to. And I mean, third, just on the process, our legislators are meeting tonight, and they don't know the details of how any of these bills would work at the local level and affect the county, and that's why they seek our recommendations. So I think it's totally appropriate that we meet and give recommendations on local and bi-county bills, certainly, because when I was a state legislator, and I bet Councilman Rice would agree with me, we very much counted on the recommendations of the council, and it drove us crazy when we didn't have a recommendation, because we would not know what the council wanted from us regarding the legislation. So anyway, said my piece. Thank you.
Thank you. Councilmember Rice.
Thank you for teeing it up, Councilmember Hucker. So here's the challenge. The challenge is because the technology is still developing, are we crafting this in such a way that gives us the flexibility to dovetail into whatever the technology is in terms of, I read through the bill very quickly as we were having the discussions. That's why I took my light off for a while so that I could read the bill itself. And it's very specific in some instances. And I think that, again, for us, we'd want to have something that's more generic. So, Councilmember Hucker, I think at this point, I'm supportive of a no position. If we came up with something that was a lot more generic in terms of its structure, then yeah, it's enabling legislation, so it's fine. I just don't want us to pigeonhole ourselves into something that the technology can't do, nor is appropriate for what we determine is locally supportive of us in terms of our mission. I will just say that I've been one who's started to be more resistant of casting these negative shadows on our General Assembly when it comes to doing the right thing. We have new leadership in Annapolis on both the House and Senate side. It is my hope that this new leadership will bring to it a new day when it comes to Annapolis. I agree with you that things were the way they were for a very long time. I hope that with new leadership that they will impart in terms of committees that there are good legislation pieces that need to move forward. It is crazy to see good legislation die in Annapolis just because that can save people's lives. That's what's happening regarding distracted driving, and I'd hate to see something just come to Montgomery that is something that we know can save lives throughout the state of Maryland, not just in Montgomery County. So I would be supportive of this as a statewide initiative, and I too, as you would testify on behalf of this. I've been in communications with the purveyors of one of the technology pieces, and one of the things I've told them in my conversation with them is that while I'm supportive, I think it's something that we need to flush out the details of and just get that around us. So for right now, I'm supportive of a no position, but I think that very quickly doing the pilot to figure out what the nuances of a bill would be, what the particulars of some of that structure may be, and what those details would be so that we can then ask for that, and then we'll be able to use that to justify statewide that this is something that we should do because we're embarking on the pilot ahead of everyone else and saying this is what we found in terms of data. You're right. As of right now, I agree with you. There's no data out there, so the state's not going to move forward with something without that sort of support. But if we have the data around it, so I do support Captain Didone in terms of his initiative, let's get the pilot. Let's get the information, see what's out there, see how it works, and then we can use that to justify a statewide initiative. So that would just be my thought in terms of how best to move forward.
Councilmember Giwando.
Thank you. And just briefly, I wanted to state, because I didn't state this at the beginning, it's a huge problem. And I appreciate the steps that the police department has come forward with today that they want to move forward on. And I'm 100% supportive. I just have concerns with this type of monitoring and the path that leads us down. But certainly distracted driving is a crisis, and we need to be doing all that we can to address it.
Thank you very much. It seems like we have a difference of opinion here. So does someone want to make a motion?
Move no position.
Say it again.
Move no position.
It's been moved. Is there a second for no position?
Second.
It's been moved and seconded for no position. All those in favor, please raise your hand.
No position.
We have 1, 2, 3, 4, 5 with no position. And for those who disagree, are not in agreement with no position, I guess it's Mr. Hucker and 3, Reamer and Mr. Albornoz. Okay. Do you need, is that good?
We could, may I ask a question?
Sure.
Of course, the council can take up anything at any point in time, but if Councilor Hucker wants to continue working on this and talking with colleagues, perhaps we can reconsider at a future time.
Okay. Next is Bill 10120.
Okay, so moving into a series of bi-county bills. This bill deals with Park and Planning's mandatory referral process. And I know council is very aware of the process, but just to repeat the baseline here, that process requires public entities, state, county, municipal entities to if they're going to conduct certain activities, to submit a project to Park and Planning for approval. And the types of activities we're talking about are acquiring, selling land, locating, constructing, and authorizing a road, park, public way, ground, public building or structure, or a public or private utility, or changing the use of, or widening, narrowing, extending, relocating, vacating, or abandoning any of the items I just mentioned. So under the current process, if an entity submits a project for review by Park and Planning, it's deemed approved if Park and Planning does not act within 60 days. Of course, even if the commission disapproved it on its own or disapproved it because it didn't meet that 60-day shot clock, the submitter can ignore that disapproval. But essentially what this bill does, it establishes a process for Park and Planning to make sure it's got a complete submission before it acts and before that 60-day shot clock is triggered. So it defines the term complete submission, and it sets up a process for going back and forth for the commission to try to get all the materials it needs to make a decision. And essentially, that back and forth can go on for 3 times. Park and Planning can ask for more information 3 times. And the submitter, if it wants to stop after 3 times, can essentially say to the commission, we've given you what we can give you. Please act on our submission. Last year, this bill was introduced in a different form, and on behalf of the county executive, we worked with Park and Planning to develop amendments that look exactly like the bill you have in front of you. So the county executive supports this bill. Last year, county council did not take a position on the original or amended version. This bill, as you see it, was approved by the Montgomery County House delegation, but was eventually withdrawn because it wasn't moving in the Prince George's County House delegation. And that, as I mentioned, the county executive supported this bill last year and also supports it this year.
Okay. Councilmember Friedson.
Since this was a bill that was worked on last year by the planning department, is there a reason why we don't have an agency recommendation?
We typically see that recommendation tonight when they submit their testimony, but happy to get back to you even this afternoon.
Councilmember Friedson, I had reached out to staff at Park and Planning, and they had reported back as of the printing of the packet that they didn't have a recommendation yet because the planning board was scheduled to take it up the week before and then got delayed, and they hadn't taken it up yet.
Okay, this is another example. I think it's premature for us. I don't have any real issue with the bill, but for us to be weighing in on a bill to impact an agency without the agency weighing in on the bill doesn't seem to be a very good process to me. And so I think we should take no position, and we can take it up at an appropriate time once the agency formally sends over the position.
I totally understand that perspective, but just in case I wasn't clear on what happened last year, we did work with Park and Planning staff. They did take it to the planning board, and the planning board approved it. But fair enough, we haven't gotten a position yet this year.
And it went through, and we didn't even take a position on it. I just think we ought to wait. If they have changes that they'd like to see, there's new members of the planning board, a new member of the planning board since then. I mean, to me, think that this is an example that we shouldn't be taking a position on a bill on an agency that presumably they're requesting without them weighing in on if it actually does what they think it ought to.
Councilmember Glaze.
Thank you. I agree with the sentiments that were just shared because we've spent a year on this council, 4 new members of the council, and after we went through the legislative session last year, we had many an internal conversation about having the proper conversations at this point in time. And there have been a few times just today where we didn't have enough information, and I think this is another instance where we're getting the cart before the horse. There's a hearing tonight, and on some of these issues, I would like to hear what the agencies, what the community thinks, what other stakeholders think before we put our official stamp on it. And on a piece of legislation like this that affects an agency and the agency official position hasn't been presented to us, I think it is prudent to hold on and to take this back up at another time.
Is there a motion?
Well, no, may I?
Go ahead, please. You didn't have to wait. Go.
Sorry. Well, I think there's a distinction between taking no position and not taking a position yet. Because taking no position often is the council's official position, that we have no position, versus we need to hear from someone. So I would have recommended, I did recommend that on the police, the distracted driving bill, but, to your point, I'm comfortable on this basis because I'm pretty confident that the planning board will support it since this is designed to empower them, and I believe they requested it last year. But I would recommend if we have a question, let's just hang back and wait till next time. There's better to wait than to take no position indicating that we don't actually have a view.
Councilmember Friedson.
Yeah, I was always under the impression of the year that we've been here, to Councilmember Glass's point, that not taking a position is no position, that we have not differentiated here between taking no position on a bill and not taking a position on a bill. I understand what you're saying, that those two things could be different, but up to this point here, we have not distinguished between those two things, and I have not ever seen a scenario. In fact, it says no position, last year the county council took no position on the bill. This came before us, we talked about it, there were issues that were being worked out, and we didn't take a position on the bill. I'm fine if we say deferring is different than no position, but that is a policy decision that we ought to make, and I think it's another reflection of the fact that we still haven't really fleshed out this process, because those are two different things. Saying deferrals and no positions are different, and a no position is a formal position, as opposed to saying no position is not taking a position on the bill, which would reserve your right to get colleagues who are interested in it to take it back up at a later date. I mean, I view those things as different. That's a different process. And I think we ought to decide at a later date if that's the process that we're going to undertake here, because up to this point, those two things were a distinction without a difference, at least as long as I've been here for the year that I've been here.
Ms. Myhill, please.
So I did want to clarify that Councilmember Raymer is right. The council you can take a position of support or with amendments, oppose, or no position, which is a position of no position. This council also has deferred taking a position, which means that you can come back at a different time and take a position.
If we take no position, presumably it's settled.
Right. If you take no position, then it doesn't come back to you unless a majority of the, right. But if you defer taking a position, if the bill moves far enough along in the process, it often does come back. Right.
There's been a motion that we take no position.
Yeah, I'm fine keeping it as no position, but you can defer.
Go ahead. Go ahead, please.
I don't interpret no position as an abstention, which is the definition I'm hearing. I don't want to abstain on this, nor do I want to abstain on the previous piece of legislation regarding pedestrian safety. My position on no position is that I simply want more information, and that is my interpretation.
Go ahead, please.
If you want more information, then what you want is to defer taking a position.
Well, we still have a motion on the floor. All those in favor of no position, please raise their hand. Okay, so that's 3. And all those in favor, and those who disagree with the no position, please raise your hand. And those in denial. And then it'll be a defer. Does anybody have a motion for deferral? Yeah. You have a motion for deferral. You want to second that?
Yeah.
It's been moved and seconded that we defer. All those in favor, please raise your hand. That's 1, 2, 3, 4, 5. Yeah, that passes. Thank you very much. Go ahead.
Mr. Chair, Mr. Vice President, given the new lexicon that we're using, or I would like to go back to the previous legislation, Mr. Hucker and Mr. Wallstreicher's piece, to personally change my vote or get the temperature on the council to see if that no position could go back to a deferral. We can take that up after, but I just want to make that.
Yeah, we'll take that up after.
Can I raise it?
Yeah, go ahead.
Yeah, I just want to raise a similar point. We're going to get to it later, but there could be other examples. But on A13, MC 2120, council staff recommends no position until it is clear how this impacts HOC and how it is or is not consistent with county requirements. I think that's reflective of the fact that no position has, at least since I've been here, and since Councilmember Glass, I believe, would agree, is agreeing, has been you can have a no position until more information is presented. So this is a change that we are making on the fly, and I'm kind of uncomfortable with the fact that we're changing. There's no recommendations to defer by council staff that I can see, and no position until it is clear how this impacts an agency sounds an awful lot like a deferral to me.
So if we could be clear, Ms. Myhill, if we said no position, and does that mean that it will not come back at any point?
Unless the majority of you agree to take it back up. No, it would not. Your position is that you're not taking the.
So I do believe, to Councilmember Friedson's point, that we should also have a staff recommendation of deferral, if that's what they're suggesting, rather than the language that he just read. I don't know if everybody else is in agreement with that. Sure. Go ahead.
I was going to ask Mel and Kathleen, or anybody, what's your recollection? I don't ever remember us having 4 possible positions. I remember us having 3 positions. The council is free to change its mind at any time, right? So,
But how would they ever bring it back?
well, I know I was on the losing side of a majority who doesn't want to bring things up unless a majority wants to bring things up, which is still, I think, was not going to survive. But to me, we're either favorable, unfavorable, or no position. And that can change as more information becomes available, right?
Right.
I don't remember ever taking a formal position to defer something so that it could come back later.
I don't recall specifically how we have referenced something that the plan was to bring it back when there was additional information.
Right.
If that was.
But that's the same as no position.
Bifurcated no position. But I think that there could be the flexibility, certainly, calling it a no position with the ability to bring it back when there's more information, or calling that a deferral. I think that's up to you
It's
all,
an
how
academic
you'd like
argument, 'cause
to,
we could always bring it up, right? But
you'd like to use your terminology.
if we've ever had this deferral position, yes.
Councilmember Rice, please.
So as the senior member on this group, let me refresh everyone's memory. We had support. We had support with amendments. We had oppose, and we had hold. And we would hold a bill until we got more information. So there were multiples. Let me just break it down for you and remind you, as the senior statesman on this dais, that's what it was. So again, there was the support with amendments, there was oppose, and then there was a hold. And that hold was until we got more information. And that's what we formally would say, we'll hold for more information. So those are the choices that we had before.
Councilmember Reamer, please.
I mean, I think fundamentally our intent is whatever 5 people say our intent is. Do we support a bill? Do we oppose a bill? Do we say we'd like more information? I think we just need to be clear, and this is we do have a somewhat new system here because of a bit of a change about how bills come before us. So, I think we can say we would like to hold this until we get more information versus we're actively taking no position. When we actively take no position, to me, that signals to the delegation that we don't particularly care what you do because we're just not taking a position on this. And that can be very risky unless that's really what we mean. So I think we really do need to know what we mean, what the council means internally. And it may not have been clear on the previous bill about distracted driving. So I think motions need to be very clear, and we'll leave it to the chair to ensure that the motions that are before us are very clear.
Well, and to that point, as an example to Councilmember Friedson's point about the HOC Bill 520, where it says oppose this bill until there's clarification on how it impacts HOC, then that would show that if we supported the council's staff recommendation, then that's exactly what we're saying. We're supporting their recommendation, but it should come back once there's clarification. So I think that if we're clearer, rather than have to go back to the deferral, if we're clear on what we say, that we support the council staff recommendation with the idea that it come back, just as this wording is, when there's future clarification, I believe that would clear that up. I don't know if anybody else believes that, but I believe that. Okay? So on this one,
Move to hold.
it's been moved to hold.
Use that word yet, hold?
Say it again?
That's fine.
All right.
Yeah, what's the next one?
Okay, so
Yeah, I think,
on
go
this
ahead.
particular bill, you already took a vote to defer taking a position.
Yes.
To hold it.
And I think we have to now be clear on what all of these mean so that we don't have this discussion each time. Okay, so we're finished with that one.
Which one did we just?
On 10120. On 10220,
Okay, so 10220 relates again to our Bi-County commissions, and that would be Park and Planning, WSSC, and also the Washington Suburban Transit Commission. And right now, under state law, each of those agencies are required to adopt regs dealing with conflicts of interest and lobbying before the commissions. And they're also required to prepare annual reports on issues relating to conflicts of interest and lobbying, and to submit the reports to both Montgomery County and Prince George's counties. I think Delegate Carr looked into this. Of course, he's here and can speak for himself. But, I mean, essentially couldn't find these reports, and nor could we, and nor could any staff, I think, that he spoke to. So this bill requires each commission to publish its annual report on its website. And the county executive supports.
And it's the council staff recommendation that we support as well. Is that without opposition? Go ahead, please.
Yeah, I mean, I just think it's another example of we don't have the agency recommendation. I have no problem with this. I'm just curious, one, what the problem that we're solving, and two, we don't have an agency recommendation. And while I totally support transparency and accountability, believe in this probably being a good way to go, I again think that before we vote on something in a formal and public setting, that we have an agency recommendation for.
Yeah.
I would motion that we hold or defer, or defer to hold or hold to defer. But I don't think we should take a position before the agency takes a position.
Councilmember Glass. I concur. The agency is here. Did you want to hear from the agency? Are you?
WSSC. Right. One of the agencies. Come on.
Well, one of the agencies, please.
Not all three. You're the only one to pick on.
You're going to need to speak on the microphone, please.
Pass them to staff if you have them there, and then say what you.
Good afternoon. My name's Guy Andes, Government Affairs Manager for WSSC, here on behalf on PGMC 10220. WSSC supports this bill with an amendment that we discussed with the bill's sponsor to have the date certain move from April 15th to April 30th. Let him concur that. But other than that, we're supportive of the bill with the amendment that he said he'll proffer.
Thank you.
And then I've also distributed letters on the other three bills that pertain, or other two bills that pertain to WSSC.
You. Are there any other? Is there any other discussion on this? Okay. Do you want to support the staff recommendation or support? Say it again.
Move favorable with the amendment.
Or with the amendment. It's been moved and seconded, favorable with the amendment, with staff recommendation with the amendment. All those in favor, please say aye. Opposed? There you go. Yeah, whatever. Yeah. Thank you. It passes, right?
Yeah,
Yes.
passed. I think Evan and I thought we should hold.
You wanted to hold. You
There's
and
two other agencies.
right. Okay, but it passes. All right. Next is 10320.
Okay, this bill expands provisions of current law that prohibit WSSC and its contractors and subcontractors from discriminating based on a number of suspect factors. It adds genetic information and presence of children to the list, which currently includes sex, race, creed, color, age, mental and physical handicap, disability, sexual orientation, religion, marital status, gender identity, or national origin. And it defines the term presence of children to mean the regular presence of an individual under the age of 18 years in a property served or to be served by the commission. The county executive supports the bill with an amendment to define genetic information. That term is defined both in county law, our county law dealing with employment discrimination, and also in state law dealing with employment discrimination.
Okay. It's county staff recommendation that we concur with the county executive's position. Is that without objection? Councilmember Friedson.
I'm just curious, what problem are we solving here? I mean, is there an issue with awarding contracts to firms that regularly discriminate based on genetic information?
What does that even mean?
Because I have no idea.
Would you like the sponsor to speak to that?
I guess. We've got to move this along, though. But please, if the sponsor could come forward and speak.
I'm just fine not taking a position on this bill because I don't see a pressing need for it unless any colleagues do. I don't need to hear.
Please.
Hey, good afternoon. For the record, Delegate Alcar, Good to see you all. So this bill really came out of another bill from a couple years ago that was designed to strengthen the anti-discrimination provisions in the WSSC statute to better match what's in the county law and in the state law. So out of that process, the county, that bill was to add several categories, and the county recommended that we also add genetic information. So that was the genesis of this bill, was to implement what the county had recommended from 2 years ago, and then adding one additional category to make those provisions even more consistent and even stronger for WSSC's customers, their employees, and the employees of their vendors.
Okay. Councilmember Rice.
So, Delegate Carr, from what I understand in reading through this packet very quickly in terms of what WSSC has transmitted, there seems to be some inconsistency in local law between Montgomery County and Prince George's County. Is that not correct?
That's correct. There are a lot of inconsistencies on anti-discrimination between the counties. For example, Prince George's County does not have as strong of provisions for gender identity as Montgomery County does, but that didn't stop us in 2017 from strengthening the WSSC statute to match the stronger of the two.
Okay, and I see here that the commission actually asked to meet with you and discuss this further so that they could, I guess, get through some of the challenges between the discrepancies between Montgomery and Prince George's. Has that happened yet?
We've met twice.
And so have you come to a resolution at this point?
So what I've told WSSC is, the goal of the bill is to strengthen the protections and make them better match what's in the state and county law. You'd have to ask them about what their position is on the bill.
Yeah. All right, Mr. Vice President, I'd move that we hold.
It's been moved to hold, but before we do, is there a second to hold?
Second.
It's been moved and seconded to hold. Councilmember Glass, please.
Just real quick, on this bill, of course, who's going to be against any type of discrimination? Of course, we want to end any type of discrimination, but on this bill and a series of bills that come after it that affect particular agencies for which they have not weighed in, I will continue stating that I want to hold and learn more information.
Very good. It's been moved and seconded that we hold. All those in favor, please raise your hand. We have, those who do not want to hold this bill, please raise your hand. It passes. We're holding. Okay, next is 10420.
Okay, this bill relates to land use documents and certification under penalties of perjury. You saw this bill last year and opposed the bill, as well as, I should say, did not support either the bill or some joint amendments that were developed by the County Executive and Planning Board, and I'll just walk through that quickly. The bill, interestingly, comes in its original form as last year, even though last year the County Executive had worked with planning staff and Planning Board to develop some amendments that were consensus amendments that were approved by the Planning Board. What the bill does as it comes in is it says that an applicant or designee who seeks to subdivide land in the county must certify under penalty of perjury that certain documents are true, correct, and complete to the best of the applicant's knowledge, information, and reasonable belief. And the sets of documents that refers to include a forest conservation plan exemption application, natural resources inventory, forest stand delineation, forest mitigation application, and concept plan or other local development plan that does not require either a natural resources inventory, forest stand, or forest conservation plan exemption. The amendments last year, again, that were worked out with park and planning staff and the planning board, would actually expand the scope of the bill and clarify the types of documents that it applied to. And those documents would have included recorded easements and rights-of-way for property proposed for subdivision, again, the Forest Conservation Plan, any other regulatory development application as well. The amendments also changed the language of the certification a bit to require the applicant or designee to certify, again, under penalty of perjury, to the best of the individual's knowledge, information, and reasonable belief that they were accurate. Again, the county executive supported the bill last year with the amendments I've just described. County council did not support the original bill or the joint amendments, and the position was that penalty of perjury was overkill, that right now under current law, documents like this must be certified as accurate and by licensed engineers or other licensed professionals, and that if they're inaccurate and planning board believes it's not an honest mistake and there's a trouble there, they report it to the appropriate licensing board, and there are consequences there.
Thank you very much. The council staff recommends oppose.
Move oppose.
Opposed?
Second.
Well, it's without opposition. Thank you. We're going to move up. I understand we have a couple more bills, but I know that HOC, Stacy Stanton, has to leave, so we're going to move up those bills very quickly.
He had to leave.
Well, he already left, so we're not going to move those bills up quickly then. Okay, no, yeah, we got two more. The chair is here.
Mr. Katz, if I could just note that the bills related to HOC are actually they're actually be taken up by the delegation for hearing on the 9th. So you have to.
So we don't have to move him up, but we were doing that as a courtesy because he was here. Okay, thank you. 10520.
Okay, 10520 deals with an existing subtraction modification from the Maryland income tax. Subtraction modifications are, of course, Maryland's term for deductions from adjusted gross income. And under current law, individuals that fall under the definition of law enforcement officer may deduct $5,000 from their earned income, from their federal adjusted gross income for the purposes of Maryland income taxes. The bill expands that existing provision of current state law to add certain members of Park and Planning and WSSC's police departments. To be eligible, the bill requires that the police officer reside in the sanitary district if it's a WSSC police officer, or in the regional district if it's a Park and Planning officer, but also has a criteria that the crime rate in the political subdivision in which the officer lives must exceed the state's crime rate. The county executive took no position at this time. We've sought some information about clarifying the intent of that crime rate language and what that meant. The county executive is deferring a position to get more information on the intent of the bill.
There again, I guess if we want to defer. To me, a police officer is a police officer, regardless of what agency they work for. And I believe that this should be something, we can get more information, but that should be something that we do support. But what is the council staff recommendation is no position. That's without opposition. The last one that we're going to do for today is 10820.
10820 will be very quick. This does not relate to Montgomery County, so typically when it doesn't relate to Montgomery County, you take no position.
And without objection, we're going to be quick. Thank you very much. All right, so we understand on this. Now, we did want to come back to 2420, which was Councilmember Glass's concern. You, Councilmember Glass, I don't put words in your mouth. I know you won't let me, but you had suggested that your vote should be changed to defer or the.
So it goes back to what
I know, it's very nice
words
and
we're
confusing.
using here. And
Yeah.
so the motion for that was no position. Whether we are now equating no position with defer and they're synonymous, I'm fine with the vote as it was. I mean, quite frankly, I think the will of the council was made known that we want more information, and hopefully staff picked up on that will.
You have a.
But a motion
Wait,
the will of the
let,
council is-
excuse me, let her finish.
Based on your discussions, that no position means that you would like to see it back and that you're not taking a no position. That's what, then it is not,
No, that's not, I don't think everything that we did, no position
Yeah,
on,
exactly.
we want to see coming back.
Make a motion here.
Yeah,
I move to defer action on that legislative.
on 2420. Please.
I just want to clarify before I second or no, that, and I've been trying to stay out of this, but we did take a vote to do a course of action. So are we, I think the proper, I don't want to get my Robert's rules, I think the proper, you would have to reconsider that and take that off the table before you make another motion.
All right, that's fine, but we can do that, but I
Okay,
wanted
but,
to make
and
sure.
then on the substance of it, I think I was clear. I think we should oppose it, but I voted no position in lieu of oppose because I knew there weren't votes for that. So that's another calculation we all have to make, but, so just wanted to clarify that.
So we are,
I move to reconsider 2420, our position on 2420.
is there a second on that?
Second.
It's been seconded. It's been moved and seconded to reconsider 2420. Those in favor of reconsidering 2420, please raise your hand. That is 3, 4, 5, 6. Okay. Those,
Now make a motion.
right.
I'd like to move that we have an official position of hold on 2420.
Is there a second? It's been moved and seconded. All those in favor of holding 2420? That passes. So we're clear on that, okay? Thank you very much. We got out but two. What a mess.